Okay, we are live. This is Attorney Vince Davis, and this is The Secret: How to Fight CPS and Win. We were scheduled to have some more guests this morning, but nobody has logged in yet. So what I'm going to do is I'm going to play a couple of videos, and then we're also going to take questions from the audience. So if anybody has any questions, we can go ahead and try to answer those questions. But here's our first video that we're going to show while we wait for people to join with questions. I was recently asked a question, and it was a very interesting question. A caller asked me, Vince, out of all of the hundreds of videos you've done on YouTube, what's the single one most important YouTube video you have done? And I thought long and hard about it. And it's probably a video I did, it seems like a year, 2 years, 3 years ago, maybe. And the name of the video is, What is Justice? I think that everyone who has a CPS case or has any type of case in general should watch that. I think it's about a 7-minute video where I'm standing in front of a whiteboard explaining what is justice. Justice isn't what you think it is. Please watch that video and educate yourself so that you will know how to deal with this judicial system and your CPS case. Okay, good morning. So we were supposed to have some guests this morning. They haven't logged in yet. Maybe there was some confusion, or maybe they just changed your mind. I'm taking questions from the audience today. So if you're watching on YouTube or a Facebook page, go ahead and post your questions. I will have them I will try to address them during the show. We have Armada Ministries. Hello, everyone. Hi, Vince. Hi, Armada. How are you? Armada, I want to invite you, you're watching on YouTube, invite you to become a member of my channel on YouTube. There are a lot of private perks that you're going to be getting as a member on my YouTube channel, including different videos, instructional videos, and also group calls where we personally will be talking to each other, or we personally will have live streams with each other. So I invite you and everybody else watching on YouTube to definitely become a member. Okay, Miss Bonnie Levy says, I have a question. I'm in the appeal phase, and isn't there a guideline or timeline we need to follow? Absolutely, Ms. Bonnie. Anytime in a legal proceeding, trial court, or appeal, there are deadlines. There are timelines that you have to meet. For example, if you're in California and you file an appeal, and I'm not talking about a writ, but if you file an appeal, you have to do it within 60 days of the court's judgment that you are unhappy with. So don't let that 60-day pass you. After the 60 days goes by, there is a general timeline of about 30 to 60 days where the court clerk must prepare the appellate transcript. And that consists of documents filed in the trial court and consists of the reporter's transcripts of the proceedings. Once those are filed and served on you, you and your attorney have 30 days, about 30 days, to file what's called the appellant's opening brief. And then typically the other side, the respondents, usually the county or CPS, have 30 days, and then to file their respondent's brief, and then you have about 2 weeks to file what's called a reply brief. And then the case is set for either a decision by the court without oral argument or a decision with oral argument. And once that is done, generally, I can't remember the exact number of days, but I think it's 90 days before the Court of Appeals has to render their decision. Sometimes they go over. They have that discretion to do so on especially, important cases. And if you win, if you win or lose, you have the right to seek, the losing party has a right to seek what's called a writ with the California Supreme Court. Generally, the case is sent back to the trial court if you win, and with directions on what to do: new trial, complete reversal, release of kids. It just depends what your appeal was about. So Bonnie, I hope that answers your question. And then says, excuse me, Armada says, I agree. That is your best video. Oh, thank you. Yeah, what is justice? Do you want your kids back or do you want to be right? Definitely clicks with me. I felt so blinded by all the injustice and lack of due process, it distracted me. You know, Armada, that happens to people a lot. And a lot of people don't understand or they don't want to understand at this point in their life or at this point in their case. So I recommend everybody find that video on my YouTube channel. What is justice? I think there's two of them, but you want the one where I'm standing in front of a whiteboard explaining something to someone. I actually made that video, or the client took the video. The client wanted to videotape me, and and she sent me the video, so I posted it. But I don't mention her name or anything, and you don't see the client in the picture. But yeah, so I really was trying to explain that. And the reason why I'm glad I made that video is because, I find myself explaining that over and over and over to, many, many, many different people. And I thought, I should put that on YouTube because people should actually hear this description of what is justice because it's not what you think it should be. Okay. But Armanda, thank you for looking at that. And don't forget, become a member of my YouTube channel. Parker Gigi, good morning, Vincent. Good morning, Parker. I will look into the member information. Thank you, Vince. Okay, and Miss Bonnie says, okay, I something ID the transcript is missing. All kinds of I don't know, P petition notice of hearing, all court minutes are missing. So Bonnie, when you do an appeal and the record is prepared and things are missing, what you have to do and your attorney has to do is you have to make a motion to augment the record, augment the appellate record, and to add things to the appellate record. I'm going to tell you an important thing that happened during my life as an attorney. Um, I was hired to do a case in Los Angeles County, and at the trial court level, I lost, and I felt very strongly about it. And so the client and I appealed the decision. Now, when we got the decision, when we got the court appellate record, I realized that there were a lot of things that I wanted to be considered as part of the appeal added. Well, I got a call from the organization that controls and has supervision over appeals in CPS cases in Los Angeles County. And I had a frank discussion with the head of that organization about why I thought the record should be augmented. And I don't know, the person disagreed with me, but because I was the appellate counsel and felt so strongly about it, um, she had to authorize the augmentation and the cost. Maybe it was the cost associated with. But what I want to tell you is, I got a phone call one day, months later, from a friend telling me, congratulations, you won that appeal. And I can tell you right now that about 45 to 50% of my argument was based on the augmented record. So, what the expert on CPS appeals thought I didn't need, I in fact did need it. So if you think something should be augmented, you got to talk to your attorney, make sure that he or she agrees, and you need to make that motion to augment. It can be, critical in your appeal. All right. Shannon, also watching on YouTube. Shannon, please check out my membership for my YouTube channel. Shannon says, after 2 years, my case keeps getting closed. The state files child abuse charges on me, saying I pushed my baby down the stairs. For one, I have no stairs. For two, she's not in my custody. It's reopened. And Shannon, the question is, why are they cheating you unfairly? Who knows? Who knows what their incentives are or their agenda is? It's very hard to say. Armada says, how do I get CPS Foster Court to explain exactly and specifically what I have been convicted of? My attorney just says there has been a finding of abuse or neglect or at risk of, and nothing specific. Okay, so Amanda, if you're in California, there definitely are specific allegations that have been found to be true. What you need to do is go to the court clerk and with your ID and order a copy of the file. You will see in the file something called a sustained petition. That's what the judge has found to be true, and you can read it, and you'll know exactly what you were found guilty of. Now, here's the thing: you may not agree with it, and if you're in California, you need to file that notice of appeal, talk to your attorney, maybe even get a court-appointed appellate attorney. Okay, Bonnie, thank you. You're welcome. Truth Teller, good morning. Good morning, Truth. Truth, I hope you're a member of my YouTube channel. Jessica G, good morning. Good morning. Leah says, what do you do when the CPS intake worker lies to the judge to get her case? You keep fighting. You get a good attorney, or you work with your court-appointed attorney, who may be a very good court-appointed attorney, and you fight. You bring forth evidence, witnesses, documents to show what the social worker is saying is just simply not true. Now, don't get me wrong, that doesn't guarantee that you're going to win, but you can't give up, right? And talk to your attorney and see if there's other ways to resolve this. Armada says, excuse me, I'm in Virginia. We have appealed. Thank you, Vince. Okay, good. Keep us posted, Armada. See what happens with your appeal. Okay, I don't see any other questions at this point. And I'm going to play something that I think everyone should hear. It's a YouTube short on hearsay. So here we go. In California, hearsay rules of evidence in juvenile dependency or CPS cases is different than a regular criminal case and different from a regular civil case. For whatever reason, the California Supreme Court and the legislature of California has ruled or made law that hearsay used by a social worker can be used against you in a proceeding. The reverse is not true. You are not allowed to use hearsay in a proceeding against the social worker. Now, there are a lot of exceptions to the hearsay rule, and in California, there's hearsay, which is an out-of-court statement used in court to prove the truth of the matter therein. There are many exceptions, but when you're coming to lay out your case and strategize your case, remember, you have to fall under one of those hearsay exceptions in order to use that important evidence. Call me if you have questions. Okay, the topic of hearsay evidence and the rules of evidence can get very complicated. I've told a story before about a guy who went to court on a Friday, came to see me on Saturday because he lost, and he couldn't understand why he lost. He, yelled to the highest mountain that that judge was corrupt. And the problem was, and it took him a while to understand this or to even accept it. I should say accept it because he understood it when I explained it to him. That all his case was based on total hearsay. And they weren't even statements, they were documents. Documents that he said were were medical records of the child and school records of the child. And he thought that if he brought those documents to court and showed the judge, that the judge would read them and rule in his favor. Okay? Problem is, judge is not supposed to even acknowledge or consider those documents unless he makes the hearsay rule and he meets the standards for the exception. So there's something called the business record exception. That means if they're business records like medical records or school records, the judge is supposed to consider them if, and this is the big point, if you have followed the rules to get business documents into evidence. How do you do that? Well, in California and most places, you have to subpoena the records in with the custodian of record. And the custodian either has to come and say, yeah, these are correct records, true and correct records, or provide a declaration that says the same thing. All right. So, in a lot of cases, I just subpoena the custodian of record and tell them to, come on in. A lot of them will call me or have an attorney call me and says, well, what if we produce the declaration? And I say, I don't know. Let me see the declaration first. Because sometimes you get a declaration that's doesn't follow the rules or the evidence code, and then you have the records in a faulty declaration, and then you can't admit them into evidence, right? It gets complicated. Talk to your attorney about it. All right. See, we have some more questions. Miss Bonnie, watching on YouTube. One more question. Is there anything that I should do? They're stating I don't have a bond with my baby, that having him for the first year of his life, we were together every day, that we didn't bond. Well, I don't know if that's true or correct. Sounds kind of shaky to me, but there's one thing you can do if you're in California, probably in other states, you need to talk to your attorneys. You need a bonding study. So at the hearing where they terminate your family reunification services and set the termination of parental rights hearing, the 2-6 hearing, you need to ask the judge for a bonding study. Now, I'd say you're probably 60 to 70% chance that you're going to get the bonding study ordered. There is maybe 40 to 30% chance that the judge will say no bonding study. And then what do you do? Well, there's a lot of things you can do. You can appeal that decision. You can file a new request for a bonding study with new information and new facts. Talk to your attorneys about that. All right, or give me a call. 888-888-6582. Miss Bonnie says, "How is that possible? My son has acts in." Okay, I don't know what that means, Bonnie. Oh, and then she says, "Anxiety separation. He doesn't want me to leave the room. When I go visit him, he doesn't want to make other kids to do anything. He wants his mommy to do it." Okay, Miss Bonnie, if this is accurate, perhaps you've been taking videos of your visits, or you can bring in people that have witnessed this, right? Or you need to get that bonding study. And then Miss Bonnie says, "I call him on video chat. We stay on the phone for hours. He's devastated. How can I prove that we have a bond? Anybody can clearly see this except CPS." Right. CPS will never see it. They want the child adopted by someone else, some stranger. And they think that's going to be the best thing for him. But when he turns about 7 or 8, he's going to realize, you know, things aren't accurate and aren't true. And, he's going to start to wonder, where's my real mommy? Right. And that'll affect him for the rest of his life. Okay, Armada says, "How do I get my children an independent private psychological, medical, and educational assessment for evidence for the appeal if they are in foster care?" Well, first of all, on appeal, you can't bring in new evidence. So you can only bring in the evidence used at the time of trial. So if you if you didn't bring in that evidence at the time of trial, you're, SOL on that issue. You can only use evidence that was attempted to be put in or actually used at the time of trial, Armada. So I hate to tell you that news. So if you wanted to bring in that evidence, do it at the time of trial. All right. Jason says, "I am in Florida and I just lost my rights." Okay, Jason, talk to your attorney. File that notice of appeal. Got to get that going. Armada says, "CPS just filed a petition for immunizations, even though I filed a religious exemption with them. The judge signed off ex parte and they immunized my children!" Exclamation point. It is appealed. What else should I do? Armada, I think you said you were in Virginia. I'm licensed to practice in California. Um, you need to talk to an appellate attorney about that issue. And you need to talk to perhaps a civil rights attorney about that issue to see if your rights have been violated, not only with just the pure immunization, but the fact that it was done ex parte and you may not have been given appropriate or reasonable notice under the 14th Amendment of the Constitution, the right to notice and the opportunity to be heard. Those are real rights. And sometimes I do get the impression that, Constitution doesn't apply. Okay, Eves says, "Good morning. They recently terminated our rights from our 2-year-old. She's been in DCF custody since last year, ripped out of my arms 4 days old, and my attorney is horrible lack of care." Okay, Eves, if you have a recent termination, you need to talk about your attorney or to another attorney about filing a notice of appeal. There may be, sometimes in these cases, there's a lot going on, and every case is different, and people are somehow screwed different ways, and, they lose their children. So you need to find out by talking to an attorney what you should do. And if it's not your attorney, which I do recommend, but if it's not going to be your attorney, also find another attorney to speak to get a consultation. This is, I tell people this is the most important case in your life, that you'll ever have. So make sure that you're talking to the right attorneys to get that type of, advice that you need. Here's a video that I did a while ago on how to talk to your attorney, your court-appointed attorney. Let me give you some tips on how to talk to your prospective CPS attorney or even your CPS attorney when you speak to them in person or on the phone. The first thing you want to tell them is not a story of your case. Do not tell them that. Put a fence around the story of your case before you tell the story. Be ready to tell the attorney the posture of the case, where you're at in the case, the next court hearing, and what type of hearing it is. And then, if he or she has the time, you can tell the story of the case. A lot of times, the story has no impact on the different phases of the case. I know that sounds strange, but each phase in a CPS case is different from the previous phase. So what happened 2 phases ago may not be relevant now. Call me, 888-888-6582. That video is so important because a lot of people that I talk to always talk to me about phase 1 of a CPS case. In a lot of cases, the person is not in phase 1. They're like in phase 4 or 5. And if that's the case, phase 1 is irrelevant to you winning and getting your child back now. So keep that in mind. It's not, when you first talk to an attorney, I usually ask people, and it's kind of a test, like, how can I help you? What do you want me to do? You'd be surprised what people tell me. Sometimes they tell me, I don't know. Sometimes they tell me, I just want you to listen to how I got effed over. Sometimes they tell me, I want to know how to get my kids back. Or I want to know how to sue the social worker. Now, when people tell me that, I think I can work with this person. They know exactly what they want. These are very tough cases. And I understand that a lot of people are so emotionally and psychologically affected by their children being taken away. I can't even imagine it. Can't imagine it. But I see it with clients. I see it with people all the time. Are they really taking your children away from you? Yeah, that's what they're doing. So I think, just my own personal opinion, everyone should focus on getting the child back, or if the case is over or near over, think about suing the social worker. All right. Armada says, CPS refused to investigate my very credible claims of sexual abuse by my strange husband toward my 15-month-old. They said my concerns were not valid and claim I have a mental disorder. Okay, Armando, if I had a dollar for every time I hear that type of scenario, I'd be a multimillionaire. You know, it's difficult to understand why people don't even want to investigate these allegations. Now, I've been involved in cases where the allegations turned out to be true. I've been involved in allegations that, in cases where the allegations were false. But how do you know unless you investigate? Sometimes social workers just look at you and determine, you're a nutcase and decide, well, I'm not going to investigate it. And that's where the danger comes in. Amada, what if they're claiming that you have a mental disorder? What you need is a psychological evaluation performed with a written report by a psychologist who will come to court and testify that no, Armanda doesn't have any mental disorder. So that's how you solve that. You're not going to be able to solve it with your pleas and your trying to show them that you don't have a mental disorder. If they branded you mental disorder, you got to come up with a report and an evaluation to make them believe otherwise. Truth teller, how can we get the laws changed? That's one of my favorite questions, truth teller. You have to vote. You have to get your own candidate who's CPS sensitive to parents, that is, in office. I don't know what truth teller, I don't know what state you're in, but every state in the union has a state legislature that makes these laws. You can also vote for congressmen and senators at the federal level who can affect the Department of Health and Human Services, who makes the regulations for CPS all over the country. And, you can you vote or organize people. I don't know if you saw yesterday's show, but we talked about that at the end of the show with two people from Yolo County in California and how they're trying to make changes and how a woman in Northern California has been effective in helping to make change in the system. That's what you're going to have to do, Truth. Truth, also look at my YouTube channel and please consider becoming a member. Monia says, good morning, good morning. Good morning. Eve says, exactly how long do we have after our rights have been taken to appeal it? If you are in California, I believe the number of days is 60 days. But if this is what I tell people, if you're at court and your rights get terminated, before you leave court, go to the clerk's window and file a notice of appeal with your attorney. That way you don't have to be calling your attorney, hey, did you file the notice of appeal? Did you file the notice of appeal? They may not have filed it. A week goes by, 2 weeks, 4 weeks, 6 weeks, and all of a sudden, you might miss the filing date. So that's what I have to say. Okay, Eve says, okay, you're in Florida. Okay, so Eve's, I'm only licensed in California. So what you need to do is talk to a Florida attorney. You may be able to Google it and then verify that with a Florida attorney. You could probably do it on a phone with a free, 10-minute phone consultation. All right. Truth teller. Yes, I saw yesterday's. Okay, great. Great. So, we talked about how to make change, especially in this CPS system. All right. All right. We don't have any more questions. And it's Sunday. And we didn't have our guests. There must have been some mix up. So I'm going to end the show at about 30 minutes. And I want to thank everybody for watching on this Sunday morning. And, I'm going to be watching football playoffs today. I'll be rooting for my teams. All right. So tomorrow, Monday through Friday, we're going to have a show at 7 p.m. Pacific time. I hope to see you all there watching, posting your questions. All right, everyone, have a good day. Bye-bye.